Hey folks, this is Sean C. Fettig, host of Deep Dive. You may have noticed we've released a couple of teaser trailers recently, and if so, you know that we're on the brink of launching a limited series that could redefine your understanding of our nation's current trajectory. This series, After America, is set to premiere in late June, and it's dedicated to probing a question that grows more urgent with each passing day as the 2024 election draws closer and closer. And that question is, what would democratic backsliding, or worse, a rise of authoritarianism, look like in today's United States if it were to happen? In the lead up to this series, we are re-releasing past episodes of Deep Dive each Sunday that explore themes and issues that are strikingly relevant to the questions we'll tackle in After America. Each episode serves as a stark reminder of the fragility of our democracy, throwing some light on the forces and the people and the groups threatening it, the immediate danger that authoritarianism poses to our nation, and the actions we can, probably must take to confront and counter these threats. Last week, we revisited an intense conversation that I had in June of 2022 with Jason Van Tatenhove, a former insider of the right-wing militia group The Oath Keepers. Jason's firsthand account of the group's activities, including their active presence on the Capitol grounds during the January 6th insurrection, is, in a word, chilling. His testimony before the January 6th House Committee exposed the ongoing threat these groups pose to our democracy and our nation. Jason will join us again in the After America series to dig further into this, who these groups are, how dangerous they remain, and ultimately what they want. This week, we focus on an equally critical aspect of our democracy, the judiciary, by re-releasing an episode featuring Dr. Sarah Benesch, a judicial scholar who advocates for the necessity of an independent judiciary in maintaining a functional democracy. This episode, recorded in the aftermath of the destabilizing fall of Roe v. Wade in the summer of 2022, focuses on the profound rightward shift of the Supreme Court since 2020. We discuss the sweeping impacts of the court's decisions on American life, alongside the ethical and legitimacy crises it continues to grapple with. Dr. Benesch, Jason Van Tatenhove, as I already mentioned, along with about 20 other experts, researchers, journalists, and authors, are joining us and contributing to the After America series. So as we approach the launch of After America, I invite you to join us in this crucial exploration of our nation's future. Keep tuning into Deep Dive on your favorite podcast platform each Sunday to revisit these past relevant episodes, and follow and like Deep Dive to stay updated on all developments related to After America. The clock is ticking. Democracy's at a crossroads, and the time to act is now.
And we know that the court has preferences that we not use race at all, right? That's Roberts' famous line, is the best way to end, The best way to end discrimination on the basis of race is to stop discriminating on the basis of race. Mm-hmm. Never making a distinction between the reason for the discrimination.
Yeah. Lovely. Thank you.
Yeah, it's really insightful.
Welcome to Deep Dive with me, Sean Fettig. I'm a political scientist, and I'm interested in how our government and our politicians influence our lives, but also how our personal stories influence our politics. In this podcast, I may focus on topics in the news, but this is not punditry. Instead, I dive deep into issues and stories with my guests, behind the headlines, beyond the basic narrative that is often crafted by the media and our politicians, to help us better understand each other and why we think and feel the ways we do. I'd like to ask that if you enjoy this podcast, or you think that a friend of yours might enjoy it, or even just a particular episode, please do share it with them or give it a like on your favorite podcast platform. It really does help to spread the word. You can also follow the podcast on Instagram at Deep Dive with Sean, on Twitter at Deep Dive Sean, and or subscribe to Deep Dive with Sean C. Fettig at YouTube. And as always, if you have any thoughts, questions, or comments, please feel free to email me at deepdivewithsean@gmail.com. The United States Supreme Court began their new term on October 3rd, and based on the cases that the court has accepted for review, this term looks to be every bit as controversial and consequential, if not more so, than last term. On the docket this term includes cases that could dramatically impact things like affirmative action programming, voting protections, the ability of a state to regulate industries beyond its own borders, and if the Constitution allows state legislatures to be the final say in how elections are administered within their respective states, setting up a nightmare scenario in which state legislators could overturn the outcome of elections. To discuss some of these cases and potential implications for continued reshaping of the American legal, political, and social landscapes as envisioned by the current Supreme Court, I've invited a frequent deep dive guest back to the podcast, Dr. Sarah Benesch of the University of Wisconsin-Milwaukee. In addition to the cases on the docket, we talk about the continued fallout from the Dobbs opinion overturning Roe, the court's sinking job approval and legitimacy, if Justice Thomas should recuse himself from cases involving the January 6th coup attempt because of his wife's seemingly active role in furthering that goal, and the impact of an addition, Justice Ketanji Brown Jackson's first term on the court. Let's do a deep dive. Dr. Sarah Benesch, fan favorite, welcome back. How are you?
Fan favorite. Thank you. I'm good. Thanks for having me again.
All right, so let's just jump right in. The new Supreme Court term starts October 3rd. By the time this is released, they will have been underway, for better or worse. So let's start with what seems like the obvious marker for the court, which is the continuing fallout from Dobbs.
Mm-hmm.
So since that opinion, public approval for the court has tanked. And the trend is similar across numerous polls, but Marquette Law School has the court's approval currently at 38%, which is down from 44% in May, which is down from 54% in March. And in September 2020, approval for the court stood at 66%. So this is significant in a very short period of time. And we think this matters. I've definitely argued, probably ad nauseum, that, that the Supreme Court is the last bulwark against potential chaos. So, I'm a bit nervous, but I don't know. I don't know what that looks like. So what do you think?
Yeah, I think it's really hard to figure out what a complete tanking of the court's legitimacy would mean or look like. I think, the obvious implications of legitimacy are, problems with the court's power, which is going to mean that litigants aren't going to behave in ways that respect the court's authority to make decisions, and people aren't going to hold them to account when they do that. And I think that's, one of the indicators of that is this fairly popular movement to make some major changes on the court. And I think we've maybe talked about that in one of our earlier episodes when we talked about adding justices or coming up with some sort of a term limit or something like that. I think that those kinds of issues are getting a much more serious play today than they have in the past. And part of the reason is the court's legitimacy. So I think that the power that the court has as sort of this favored institution is waning. I think, obviously that has implications for democracy, given that the court was always the highest approved of institution. And so when the court even is losing legitimacy, and we know that Congress is still not popular and the presidency is still not, super popular, it just sort of begs the question of what is government going to be able to do if not for the belief of the citizenry that they're doing things that ought to be complied with and are in our best interest. So, I think there's lots of consequences for the loss of legitimacy. And I think there are things, that we could talk about that the court could do to maybe help attenuate the problems that have been caused. You mentioned the Chief Justice, I think in your notes to me, about, what he could do, because he's sort of been known to be very interested in the court's legitimacy, right? And very attentive to the way that the public perceives the court. And you suggested, maybe I shouldn't put words in your mouth.
Go for it.
You suggested that what he might do is make decisions differently, which is an interesting proposition, right? He just was out on the circuit talking about the legitimacy of the court and saying, people shouldn't feel differently about the court just because they disagree with our decisions. Well, it just so happens, Justice Roberts, that most of the political science research suggests that that's exactly what people do. There is a component of decisional approval in people's perceptions of the courts, and Dobbs is really not popular. I think some people suggest that it's not popular because it's so activist, but I also think there's a really good chance that Grutter is going to be overturned, which is another big precedent. But affirmative action is not as popular as bodily autonomy and integrity. And so, I'm not sure that decision will have as big of an impact. But what could the justices do to help their legitimacy? They could maybe comply with some ethics rules that the rest of the judiciary has to abide by. Maybe they could think a little bit more carefully about the appearances that they're making. And, for example, not go talk at Mitch McConnell's institute. I think they could think about that whole shadow docket decision-making thing that they're up to, and maybe make some changes in those kinds of processes. So I think there are some things they could do. Whether or not they'll do them is a completely different question.
I do think that the justices' reaction to this is somewhat interesting. I'm in the same boat with you. I do believe that there is the potential that there's an overturning of at least one significant precedent coming up, if not a couple of others, which to me feels as if both their reaction and, the all signs pointing to the potential for overturning of other precedents, to me means that it's just not landing with them. Like, they're not reading the room.
Right.
And I don't know if they're willfully blind or they believe what they're saying, but they definitely don't seem to be embracing the idea that anything that they're doing is contributing to a legitimacy crisis for the court. And one is, you mentioned Chief Justice Roberts. I at least know of one speech that he gave in which, and you referenced this, he said that the court's always issued controversial decisions, and then that, issuing controversial decisions should not impact the legitimacy of the court. And I think that's not entirely the issue. It's that people believe that precedence matters, at least also, and that this court didn't lay out a thoroughly clear reason for overturning that precedent. It felt in the Dobbs decision as if they didn't even really try that hard. And Justice Alito told the Wall Street Journal that questioning the court's legitimacy crosses a line. And it just, then just left it at that. And it just all seems so tone deaf to me.
Yeah. And I think, part of that is sort of this, I don't know if it's a conscious delusion or a subconscious delusion that, they're just making their decisions, based on their interpretation of the law, that whole discussion we have about the myth of the courts and the myth of legality. And I don't know if I suppose if one subscribed to that belief and one thought that that's what one was doing, then why would people criticize you to the point of not approving of your institution's role in democracy? Like, that seems really problematic. But the issue is that isn't what drives their decision making. And so when they make a decision like the one in Dobbs and rely so heavily on this idea of original intent and on this notion that we ought to understand everything about the Constitution and about the law as it was written at the time it was written, leaving our country basically in the 1800s, maybe that's what people are reacting to, that's not a particularly legitimate way to make decisions. Or maybe people are reacting to the ethics violations, the role of Justice Thomas's wife in the January 6th issue. Maybe they're reacting to these really politicized appearances. I think we often, and by we, I include me, don't give the public very much credit for being knowledgeable. But I do think people can see when there's a mismatch between what people say is happening and what they're actually doing.
So let's dig in a little bit into originalism. And you bumper stickered it just a moment ago. But this is one of a number of judicial and constitutional theories that's evolved in pursuit of providing some structure around the application of things in the Constitution. But originalism seems to be pretty clearly where this conservative court is heading. And so I'm wondering, what is originalism beyond the bumper sticker, and how has it been applied in past? And I guess, if you're up to it, is it a legitimate theory?
Yeah, I think those are big questions that, law professors have spilled a lot of ink over trying to answer. And I think it's certainly the case that Justice Thomas has revolutionized this area of law, and that Justice Scalia was a strong player in that, and that their presence on the Supreme Court has caused litigants to pitch arguments that are based in originalism to a degree that, we didn't see before they were on the bench and before they were so in tune with this theory of constitutional interpretation. But, I think a couple of things about originalism. I think the first thing is that I'm not certain that it's the right answer if the question we're asking is how ought we interpret the Constitution. I think originalism is certainly an answer, right? It's a theory that we could understand the language in the Constitution based on its text as it was meant when it was written. But I think that kind of backward-looking understanding of our Constitution is problematic. And then the other thing I think about originalism is that there's not very much evidence that it actually matters in terms of having an empirical effect on decisions. There's much more evidence that suggests that originalism is a tool to effectuate a policy that is preferred far before the originalist analysis comes. And I think we need to know more about that. I think we need more empirical observation and modeling of Supreme Court decision making. The only article that we have is one that uses the litigant's arguments as the test. So if a litigant makes an originalist argument, is a justice more likely to agree with that litigant, even independent of their ideology? And the authors find that that is not, in fact, the case, that they agree with liberal originalism arguments if they're liberal and conservative originalism arguments if they're conservative. So there's not much indication that it actually matters. And so then I guess you get back to the whole question of whether the justices are so unconstrained that they needn't worry about all of those, pesky legal things like text and precedent and all those sorts of things.
Are you starting to feel like that might be the case with this court?
What?
That they aren't so bothered with these pesky things that we give a lot of weight to, mainly because they've been given a lot of weight to, right? It's not like academics just like created the importance of precedents out of thin air, right? Like that is something the court itself lent a lot of weight to over the years, right? And that's just one example. But it feels like this court is willing to say, like, that's not the thing that's going to stand between us and whatever outcome, whatever outcome we're in pursuit of in this case.
Yeah, I think that's an interesting question or an interesting argument. Is this particular court, so this natural court, less interested in some of the norms of the institution itself in a similar way, I suppose, as the last president that we had was very uninterested in the norms of his office?
I always start these conversations by saying, like, I don't want to be an alarmist, but I think the reality is I'm an alarmist, and I'm gonna own it, and I'm gonna ask you to either confirm it or talk me off the ledge. But like when it comes to at least what it seems how this court is constructing its approach to originalism, I feel like what they're doing is setting up a framework for a really bleak future, frankly. And I have two things that really rattle me here. First is voting. And, this will come to a head probably with a couple of cases this term, and we'll talk about those. But voting in the original Constitution limited voting to a very specific group of people, primarily, white property owning men, but it also left the Senate elections to state legislatures. Second, this makes me worry about constitutional amendments because the court doesn't seem to care at all that amendments reflect a changing society, or at least their reasoning in Dobbs doesn't lend itself to some type of a respect for how amendments do reflect a changing society. So with changing norms and values. And here I'm talking about things like enfranchising women, giving women the vote, or outlawing slavery, involuntary servitude, or forbidding the denial of the right to vote on the basis of race, et cetera. If this court's conceptualization of originalism does not allow for amendments to be reflective of evolving norms and values, then I don't know. It strikes me that these amendments, maybe in and of themselves, will not be treated with the same deference and respect as the government and society, because it's not structured by the literal original document.
I don't know that I've ever really thought about the amendments as categorically separate from the Constitution. Is that what you think is happening? You think the justices are really in love with the original document and sort of dismissive of the later amendments?
I have that fear, yeah.
It's interesting.
Because they spent so much time in Dobbs focusing on, and interestingly, right, because originalism to me strikes me as so subjective that there are a lot of roads to history that lead to different places and help us understand different things about history on the same topic, right? They chose a very specific road that had very specific things to support their argument in pursuit of their outcome that ignores a lot of other roads that explain other parts of history.
Sure.
But it was so rooted in such an early time that I wonder what their what their approach will be when tackling issues that fall in amendments that were in, the 20th century, right?
Mm-hmm. Yeah, that's an interesting observation, John. I want to think about that a little bit. That's interesting. Yeah.
So you can't talk me off the ledge.
Actually, I think this case on this Moore versus Harper case is a good test. I mean, I've been reading a little bit about the case and I can't purport to know everything about it, but I do think that there's certainly an argument to be made that the originalist understanding of the elections clause, which is at issue in that case, was not to preclude state Supreme Courts and state constitutions from constraining state legislatures. And so if they decide to formulate an originalist argument that upholds the state legislative sort of plenary power over federal elections, I don't know. I feel like that should be something that everybody should say, whoa, wait a second. But, they're not going to do that because, like you said, there are many roads to different kinds of interpretations of history. And, it turns out none of those justices are historians, for one thing. So it's really kind of fascinating to me that as a court, they have chosen, or at least as several individual justices have chosen, a method of analysis that really is not something that their training makes them an expert in, right? Mm-hmm. So focus on precedent, focus on the text, maybe. Those are things that law schools teach people to study. No law schools teach people about the history of 18th century United States, whatever, constitutional drafting or whatever. Mm-hmm. So maybe we'll see in more, but maybe we won't be able to see because maybe they'll obfuscate enough. Did I say that word right? Where we think that they're using originalism, but they're not.
Okay, so let's talk about Moore v. Harper then. And this is the case coming out of North Carolina that has every legal and constitutional scholar on edge. And it revolves around the independent state legislature doctrine. And that's being tested here. So at issue is a challenge to the Constitution's language that the manner of holding elections for senators and representatives should be prescribed by the legislature thereof. And this doctrine, to me, I don't know, it advances a fucked up theory that essentially this means that the legislatures of states have sole authority to determine the outcome of elections, that the people, the governor, the judicial branch really has absolutely no say in things related to elections, including their outcomes. That this power lies solely with the state legislature. And I guess if we were to put this in practice or imagine this in practice, and if the court were to have adopted this theory, in 2018, then we can think about states like Pennsylvania, Michigan, Wisconsin, Georgia, Arizona as good examples of what might have happened in 2020. So if the independent state legislature doctrine had been in effect, those legislatures could have done what they were trying to do. So that's nullify election results in pursuit of an outcome that, ran counter to the popular vote and aligned more with their own preference.
Yeah, I mean, I think it's interesting. So I've listened to some scholars talk about this case, and some people think that it's preposterous to say that there be ever any sort of delegation of federal authority to specifically state legislatures, regardless of their state court and their state constitution. And so, the folks on strict scrutiny, for example, who have an obvious ideological position, right? Mm. They were freaking out about this. Like they wouldn't even call it a theory because they thought it was so stupid. But then I heard Paul Clement talk about the case for the Heritage Foundation. And he was, really matter of fact that this was a strong argument, that state legislatures were carefully chosen by the framers, that framers wrestled really hard and long over this question of who should be in charge of congressional and presidential elections. And they settled specifically on state legislatures as a way to make sure that there was a publicly accountable branch that was behind these decisions. And he characterized the case as sort of like a federal express delegation of federal power to state legislatures, which would then say there's nothing the state constitution and state court can say about it. Now, the other guy on his panel for the Heritage Foundation said, I think it's a little bit harder of a question. But I just found it sort of fascinating that Paul Clement, who used to be the Solicitor General, was sort of very dismissive that it would even be a question. And then the lawyers in strict scrutiny were so dismissive that anyone could ever make this argument. So obviously the court likes to take cases where there's, some arguments on, good arguments on both sides. But as I mentioned, I think this is a test for their theories of originalism in some ways, or at least it could be seen that way. And I mean, maybe that's what they're thinking about when they take the case. Maybe they want to demonstrate that sometimes they're going to come out on the other side using originalism. And so that we should all take originalism more seriously. But it certainly has lots of ramifications, as you noted. And, one of those ramifications would be probably the overturning of the Arizona case where the court upheld the delegation of the Arizona state legislature to an independent redistricting commission. And I think given the gerrymandering issues that we're dealing with, redistricting is exceedingly important. State attempts to try to take politics out of that redistricting, I would think this would be entirely the wrong time to change that. Mm-hmm. But that was a 5-4 decision. The chief dissented. So we could see another, precedent go down in that case.
Moore v. Harper, to me, is the type of case where, sometimes we see very controversial cases go before the court and we imagine that there's some way that the court can thread the needle on it. Mm-hmm. To me, Moore v. Harper reads very differently. And I don't know if it's because of the environment that we're in and following Dobbs and feeling really discombobulated as it relates to what is this court doing? And it might take a couple terms for us to figure that out. So to me, it seems like the only options here are they completely shred the independent state legislature doctrine once and for all, or they're going to adopt it. Mm-hmm. Right? I don't see where the middle road is on this. And I'm sure there is. I'm sure legal scholars, and I'm not one, could give me a handful of them. But that scares me, that those are the two options. And then when I look at the makeup of this court and what they've done thus far, it scares me.
That's fair.
Moving on. While we still have semblance of a country, let's move to the next case. Okay, so this is another consequential case, is Students for Fair Admissions, Inc. And this case is a direct challenge, you mentioned this earlier, to an existing precedent that was established in 2003 in Grutter versus Bollinger, in which the court found that schools can utilize race-conscious admissions programs as long as those programs were, this is the court's language, quote, narrowly tailored to further compelling government interests. And they decided this case under the Equal Protection Clause. So this case that's before them is actually a combination of two cases that were brought by Students for Fair Admissions. And one is against Harvard and one is against the University of North Carolina. But what's interesting here is that Harvard is private and therefore not subject to the Equal Protection Clause. And the University of North Carolina is public and it is subject to the Equal Protection Clause. So where the case could be decided in such a way that it impacts Harvard is that they are subject to Title VI because they receive public funds, which prohibits discrimination based on race, color, or national origin in programming.
Right.
So this goes at the heart of race-conscious admission programs at both public and private schools.
It sure does. So when the court took Dobbs, I thought, that's weird, but I can't imagine they're going to overturn Roe versus Wade. I'm sure everything will be fine. Mm-hmm. And and I was wrong. And so then now, the court takes these Students for Fair Admissions cases. And I don't think we can think, I'm sure that Grutter's fine and the court's not going to get rid of affirmative action. So I think, the fact that they took the case suggests that they're ready to change the law. And we know that there are, at least 6 justices that are interested in removing race-conscious anything, right? Even when the outcome or the target is equality enhancing rather than discriminating. So yeah, I think I expect that the court is going to, I don't know. It's interesting. So I expect on an ideological level that the court is going to overturn Grutter and the use of race in college admissions. What I think is an interesting caveat to that, though, is that that's a really hard thing to enforce. And maybe the court will recognize that that's a really hard thing to enforce. And so perhaps it won't go so far as to say there cannot be any consideration of race and maybe just tinker a little bit with the situations under which and ways in which colleges and universities can, have an admissions policy that has some sort of an equity or diversity goal. But I'm not really sure. What's your expectation?
I'm such a fatalist. University might as well start planning because these are gone.
Yeah. How would the court enforce that?
Do you think this court cares so much about enforcement?
Well, I mean, part of caring about legitimacy is certainly considering the extent to which rules and regulations that you enact are going to be complied with. So I think the general story of, any sort of separation of powers or federal system or, whatever has to at least partially include some calculation as to whether or not you're going to gain what you're hoping to gain with your opinion. I mean, so what if they decide this? And so colleges and universities say, okay, and then they continue as they were. Like, what will happen?
I don't know, though. Aren't you doing the same thing we were talking about earlier, though, which is like assuming that the court, cares about these pesky things?
Sure. I mean, we might be assuming norms. But I do think that it's, they have to recognize that, I don't know, they don't have to do anything. They do what they want.
But I think you might be right in that. I do think there are some justices that would at least consider that. Maybe Gorsuch, maybe Roberts, maybe Kavanaugh.
And they wouldn't have to just, they've got several cases that involve race on the docket in the fall. I mean, so this is one of those cases. And then, there's the Merrill versus Milligan case about the Voting Rights Act and majority minority districts. That's going to be about race. And then, Holland versus Brackeen is also about race. That being the case involving the Indian Child Welfare Act.
Mm-hmm.
So all of these cases talk about to what extent one can use race to make some sort of categorization or decision or preference or, districting line or whatever. And we know that the court has preferences that we not use race at all, right? That's Roberts' famous line is the best way to end, what is it? The best way to end discrimination on the basis of race is to stop discriminating on the basis of race. Mm-hmm. Never making a distinction between the reason for the discrimination.
Yeah. Lovely. Thank you.
Yeah, it was really insightful. But yeah, I think they definitely have those preferences and they want race to be, a criterion that we're not using for anything and to really abide by that whole, strict scrutiny for racial classifications thing, regardless of, the reason for the classification. And so they have several opportunities to engage with that idea. I mean, I think it's kind of interesting that I think it was on SCOTUS Talk. I don't mean to keep mentioning podcasts to you that maybe are your competitors, but on SCOTUS Talk, they were talking about like some of these cases and saying, is the Roberts Court going to be a tinkerer or is it going to be like a, wholesale, like overrule the precedent, start over, whatever. And the general consensus was that this is not a tinkering court. So we'll see.
Can we call it the Roberts Court anymore? I mean, by custom we can, but I think it's the Alito Court now. Then the question is is the Alito Court interested in tinkering?
Right. And no, for sure. No. Yeah. And I think it's not just, there's Alito and Thomas. And then, there's the other conservative justices I don't think are of a kind necessarily with those two. I'm not sure. I mean, some of it remains to be seen. Some of these justices haven't been around for very long.
That's the other thing is this is, for all intents and purposes, a very new court. Mm-hmm. And, it's not just a shift of one or two over the course of a handful of years. Like it's wholesale, a new court.
Right.
And we really don't have our finger on the pulse of the court. And they gave us a few shots across the bow last season, which, depending on where you are in the ideological spectrum, it's great or not. Mm-hmm. But yeah, that's why I do think it's going to take a couple of terms to really figure out like how we can measure this court.
Mm-hmm. Yeah.
You mentioned Merrill v. Milligan, so let's talk about it. And this case, once again, it's Alabama that's driving a truck through the Voting Rights Act. So in this case, the lower court held that Alabama's redistricting plan discriminated against Black voters, which would be a violation of Section 2 of the Voting Rights Act, which prohibits any voting acts or procedures that discriminate on the basis of race. So the claim here is that the Alabama redistricting map dilutes some Black voters by what's called cracking them, so spreading them into districts that, subsequently takes away their voting power, and also heavily packs other Black voters into districts, so that also serves to take away their voting power. So what do you think with this case?
I think it's a similar story that we don't want to use race to make any sorts of decisions, including decisions about redistricting. And I think that will be what it comes down to, right? Because they can do all the, the redistricting cases. I mean, I'm sure you've read at least some of them, that it's kind of a disaster, right? So that, they've got all these tests and rules about compactness and voting blocks and all those kinds of things. So part of this discussion is, again, another precedent that will maybe, fall or not, which is, I guess, the Jingle case. That talks about, when a minority group's voting rights are being diluted. And so when we should take action and create these majority minority districts. But I think from the guise of a court that doesn't like to include any discussion of race in decision making, I think that kind of whole notion of these majority and minority districts could be, in question.
All right. I don't have anything more to say about that. I'm starting to feel pretty bad.
So depressing. That was one of those cases, by the way, that ended up on the shadow docket, at least at some level.
Yep.
So the court stayed the lower court judge's ruling in that case,
so that they could implement that plan for this election, the 2022 election.
Right. Yeah.
Which I also find that fascinating when they intervene and when they don't, because sometimes they're like, oh, this would just be too disruptive to the election coming up. And in other times, they're more than willing to, allow for changes that would seem to be in relatively truncated times before elections. So
yeah, and I think what's particularly interesting about that whole issue is that some of those cases that say things about when you should be able to make election rule changes are themselves shadow docket cases. So they're like, and I don't love the term shadow docket, but, they're emergency petitions where the court doesn't provide any sort of reasoning and doesn't engage in any kind of oral argument and then just makes a decision, doesn't tell anybody why they did it. There's a case like that. I can't think of the name of it off the top of my head, but it was the case that kind of like what everyone took from the decision, which, again, is without any sort of information from the justices, was that the change that the state was trying to do was too close to an election. Mm-hmm. And so now they, throw that out whenever they don't want a change to happen. Mm-hmm. And yeah, probably, I think wasn't there a Wisconsin case and a North Carolina case that were almost the same, but they came out separate, different ways.
Yep.
So, they're not entirely
consistent.
Yeah.
All right. Another case, 303 Creative LLC versus Elenus or Elenus. Do you know how to say this?
Nope. Let's just call it 303 Creative.
So 303 Creative. This is another gay wedding case coming out of Colorado.
It is.
It's a wedding website designer doesn't want to be forced to create websites for gay weddings. And this is essentially a replay, or a sequel, I suppose, to Masterpiece Cake Shop, the other Supreme Court case in 2018, which they settled it on a technical issue and kicked it back to the lower court. So they didn't really actually settle the underlying question, which is just forcing an artist to speak, or I suppose stay silent, violate the First Amendment.
Right.
So I guess this is another bite at the apple. Well, maybe wedding cake. And, I would assume that the court is poised to actually decide definitely in this term.
Yeah, but I don't think it's necessarily it's kind of an area of law where the court hasn't really said very much. This kind of dichotomy, or I don't know, what's the word I'm looking for? On the one hand, we have free speech, right? Mm-hmm. And we love free speech in this country, at least if we like the speaker. On the other hand, we have non-discrimination principles, right? And we have those baked into our Constitution through some of our amendments, right? And that matters. And states have an interest in promoting non-discrimination, right? And so I think, I don't recall a case, maybe you can help me think of one, but I don't recall a case where the court took that head-on collision between free speech rights of an individual or the right not to speak and non-discrimination principles that a state has put forward for a public accommodation. And clearly any business that does business with whomever wants to come to them is a public accommodation, right? I think Canada has discussed this kind of tension and has favored equality, right, and favored non-discrimination. But I don't feel like the U.S. has really dealt with that. And so I think this could be a real innovation in free speech law. And of course, there's lurking in the background or sprinkled around or whatever, some free exercise claims, right?
Mm-hmm. To be honest, I'm a bit torn on these types of cases because I guess on a personal level, I really don't want to hire someone to produce anything for me if they're fundamentally in opposition to who I am. Mm-hmm. But I understand the larger argument, related to, free speech and non-discrimination.
Yeah, I mean, I think everybody was ready for a big decision in Masterpiece Cake Shop, and then, the court punted. I don't think they can punt this time.
No, I think there was a lot of disappointment on both sides for them
Yeah, I
punting
think
on
so
that. Yeah.
too. Yeah, and I understand your point. Like, at least this way you have a sign, like, don't go to this business, if they choose to exclude certain kinds of people from there. But I mean, then you get back into the whole discussion of, why we started talking about racial equality
Right.
in interstate commerce and that kind of thing.
Yep. You're also great at segues because speaking of interstate commerce, National Pork Producers Council v. Ross.
You excited about this one?
So you've hinted that you think this has implications for abortion law. So I want to get there.
Mm-hmm.
Because if you're unfamiliar with this case, the description I'm about to give you is going to bring you to the table when you hear that Sarah believes that there's implications for abortion law here.
You're going to have to really think hard and stick with me on this.
Okay, so this case gets at a practice that California, or a policy that California has implemented, I think in a number of industries, in past, like including healthcare and automobile production. But this one is related to pork. So voters passed Proposition 12 in 2018 that essentially bans selling pork that was produced in inhumane conditions. And since most of the pork in California is imported from another state, this in effect is regulating the treatment of pigs in other states. So it clearly has implications for the national pork industry. But the question the court is being asked is, if this violates the Commerce Clause by regulating economic activity and an industry that, for the most part, operates outside of the state's borders and also impacts a national industry.
I think what is sort of fascinating about this case are the hypotheticals that you could run around with if the court were to allow California to engage in this activity. So I think Sean, part of the discussion, I think what you mentioned, like almost all of the pigs that California, like almost all of the pork comes from somewhere other than California.
Right.
And so the question in this case is whether the California rule about how pigs are housed ends up becoming this violation of the Dormant Commerce Clause. And by Dormant Commerce Clause, we're generally meaning interstate commerce that Congress has chosen not to regulate, but could, right? So what the pig people are saying, the national pork producers, is that, California is making rules that amount to extraterritorial regulation. They're regulating the behavior of pork producers in other states. They are making these pork producers change their habits so that they can then have California as an export partner. And they are then, sort of trampling on the rights of the state of the states that have the pork producers in them to regulate their own industry. So usually the Commerce Clause is about not discriminating against out-of-state products in state. This is not that case, so that can't apply because California is also abiding by the same rule. And most of the California voters voted for this thing. So this is a democratically chosen policy that they want to be nicer to pigs. So how does this relate to abortion? Well, I mean, I think one could think, so if we stick with the pork production first, one could think of a pork producer who exports pork or sends pork both to California and to, say, Arkansas, and would have to deal with the fact that, say, California says that these pigs have to be in this certain size container or house, and Arkansas wants them to not be that way, right? And so this pork producer is trying to figure out how to run his or her business, knowing that these different states are imposing different regulations on them, and they're in, say, Iowa, right? So under that theory, we could have states that make rules about other things that could also then implicate interstate commerce, like climate change, like assisted suicide, like abortion pills. And so if states start regulating what companies in their state or companies that send things to their state can do in these other areas of public policy, then we've opened this really big can of worms about how states can affect policy across the United States just in their own policy making, imposing those policies on other states. You buy it?
I do.
I mean, I don't know if it will happen. And we know that, in the case of abortion pills, for example, Congress has acted, at least with respect to medication in general, right? So there is FDA regulation of medication. That might be similar with some of the assisted suicide issues. But like Vermont, I guess, has a residency requirement if someone wants to use the services of a doctor to end their life. And so that argument, that requirement might affect people's ability to travel to Vermont, for example.
Mm-hmm.
And that could impact some other parts of the Constitution, which aren't really there, but we sort of assume are there, like things like interstate travel. So there's lots of like interstate commerce issues in this case that make it, I think, it's an animal cruelty case, sure,
Mm-hmm.
but it's really about California trying to rule the other states. And that's kind of fascinating.
So we've talked a little bit about our own feelings about where these cases are going to land, or at least some of them. And also that we don't really have the read of this court. But I feel like Thomas and Alito are staunchly solid conservative votes on any case with a clear distinction.
Mm-hmm.
And maybe Barrett, I guess I don't have a read on her as well. And I think that if we can ascertain during oral arguments that Roberts is sympathetic to the liberal argument, then I think Gorsuch and Kavanaugh become the, like quote unquote swing votes.
Mm-hmm.
But I'm not sure what this means for cases like the ones we've discussed here. What do you think?
Yeah, I don't know. I think it's, I think the question of, and again, political scientists tend to just sort of reject this idea, but this question of activism perceptions of the court's role in democracy, I think can matter to some of those center justices. But again, that's a lot of speculation. But I feel like Roberts and Kavanaugh, for example, are receptive to those kinds of issues. Like, should we be making this decision? Ought we go that far on this case? What will happen to the legitimacy of the court if we do this? And generally speaking, political scientists would say none of that matters, and all that matters is their ideology. But I do think that part of what was shocking about Dobbs is how far it went and how strong the language was that Alito used. And that seems to, by all indications, have really hurt the court's legitimacy in a way that, a single decision doesn't usually do. I mean, we'll see if that continues, if the effect continues or not. But so maybe that is something that matters institutionally. So maybe it doesn't drive individual justices' votes necessarily, but maybe it affects the breadth with which they decide some of these questions and the doctrines that come out of the cases. I'm not sure. I think it's a pretty no holds barred kind of court right now.
Mm-hmm. Well, come back at the end of the term and we can talk about it.
Okay.
The Thomas affair. So Ginny Thomas, today, actually, she testified. So we're recording this September 29th, and she testified before the January 6th committee today. And so the big question is, should Justice Thomas be recusing himself in cases related to the January 6th insurrection coup?
That's completely up to Justice Thomas, Sean.
I know. I said should, though. I said should.
So the Supreme Court, so I mentioned this at the beginning, they don't hold themselves to the ethics rules that the rest of the federal judiciary has to work under. But even that, even the federal ethics rules generally allow the justices to make decisions about recusal on their own, and they don't generally require them to justify those decisions. So you probably remember when Scalia went duck hunting with Cheney. Mm-hmm. He did write a decision. He wrote an opinion to explain why he didn't recuse himself then when the vice president had a case before the Supreme Court. But that isn't anything that's required by anything. And there's lots of thinking by the court and others that recusal ought to be a last step, that really the justices should try to hear the cases that come to them. Because when you recuse, obviously that creates a problem with potential ties and sort of lessens the ability of the court to do its work. So we generally want the justices to err on the side of not recusing, but there's probably some legitimacy implications for that, right?
Yeah. I don't think it's fair to say that because she believes something, that he necessarily believes it, or that because she did that he was involved. But I mean, I do think it's fair to say that if she was involved in, some way with violent overthrow of the government, then he really shouldn't be involved in cases having to do with that insurrection. And we've, definitely seen, I mean, this gets into, like gender parity issues as well. But we've definitely seen something similar play out with members of Congress, or of an administration when their family members, and particularly their spouses, engage in, what appears to be, I don't know, oddly advantageous trading, that the link between that and their spouses who work in government and have access to non-public market information that, at minimum creates the perception of malfeasance or some lack of ethics, if not outright insider trading. So I don't see how this is such a stretch.
Right. Yeah. I mean, I don't know that we know with certainty what kinds of activities she was engaged in, do we?
No. And I think, there's definitely reason to be cagey about it.
Sure. So, I think maybe part of it depends on what they're able to demonstrate her role to have been.
I agree though. Like at the end of the day, like the perception of it or the image of it just doesn't look good.
Right. But there really is nothing we can do about it given the current rules and norms at the Supreme Court. It really is something we leave up to the justices. But, as I said at the start, I think that's a place where the justices have an opportunity to gain some ground back on legitimacy, like start showing people that you take seriously potential conflicts of interest and start demonstrating to people that you take seriously your obligation to have full oral arguments in cases that are going to set some sort of policy. Think through the implications for legitimacy of your choices that you make in terms of where to appear and what sorts of audiences to address and what kinds of topics to talk about. Those are all opportunities for the court to affect their legitimacy, as far as we know.
All right, we can't finish without talking about the newest addition to the court, so Justice Ketanji Brown Jackson. Unfortunately, she's joining the court at a time that will probably end up being inauspicious for her first term.
Right.
But, what does this mean for the court and for the country?
I mean, I think it's a powerful symbol of, the ability to rise above some of the systemic racism that continues to pervade the legal profession and other professions. Mm-hmm. I think her experience as a defense attorney is hugely important also, maybe more important than her gender and her race. But I do think the fact that she is joining the bench as the first African-American woman is something that is, really impactful for people who are watching the court. As you said, not much impact on policy likely. And it'll be interesting to see how frequently she dissents and what sorts of arguments she makes and whether those are any kind of, any sort of systemic difference from her other democratically appointed justices or colleagues. Mm-hmm. But, I think it's a really big, that first day will be a really big day for, racial and gender equity.
Okay. Final question. What's something interesting you've been reading, watching, listening to, or doing lately? And it doesn't have to be related to this topic.
I was recently in Montreal.
I saw that. It looks beautiful.
Oh, it was gorgeous. And that was really fun. And one of the things I did as, sort of the book nerd that I am is kind of tried to scope out some places in Louise Penny's mysteries. Have you ever read any of her mysteries?
No, I know the name, but no.
Yeah, she has this Inspector Gamache series that's set in Quebec. And there are some, the bulk of it plays out in the Eastern Townships, but there's a few things that happen in Montreal. So I kind of looked around for those a little bit, but it was a nice trip. It was nice to see. I went for the political science convention, and it was really nice to see people. Like we haven't been to many in-person conventions recently. So that was fun. Although when the customs agent asked me, were you here for the political science convention? I said, yeah. And he's like, how was that? And I'm like, it was a political science convention.
Geez, how small is this airport?
I know.
We're getting an influx and it's only political scientists.
No, we were huge. Like there were banners all over the city with APSA on them. It was crazy.
It looked beautiful.
Apparently it's a big conference for Montreal.
Clearly. Have you read the Cardinal series that I think they made it into, I know they made it into a TV series, but it's a series of books.
I don't think so.
Crime set in Canada.
Oh.
And it has a Nordic noir feel to it. They're very good.
Oh, cool. I'll have to look for that.
Yeah, I'll send you the information.
Thanks for the tip.
Yeah. Dr. Benesch, as always, it was fun. Thank you.
You're very welcome. Anytime.
Okay, so this court is poised to take on, most likely in my opinion, overturn some pretty significant precedents on very consequential issues this term. As I told Dr. Benish, I'm an alarmist and I'm a fatalist, but the past few years have borne me out. I feel as if I've finally let go of the pomp, circumstance, theories, and norms that have led me to believe that the country is shielded from the worst that a purely ideological court could do. And I'm not ready for it, but I won't be surprised if at this time next year, universities across the country are wrestling with a huge drop in enrollments of students of color, if politicians have redrawn their districts outside of the census cycle to explicitly erase the voting power of constituencies they don't like, and states are actively preparing themselves to overturn election results in the next presidential election that don't align with their preferred outcomes. All legal and all thanks to the United States Supreme Court. I hope I'm wrong, but I doubt I am. I'll have Dr. Benish back on Deep Dive after the term concludes in June or July next year to survey the damage. All right, next week I'm talking to Alex Vatanka, founding director of the Iran program at the Middle East Institute and author of the book The Battle of the Ayatollahs in Iran, the United States, Foreign Policy, and Political Rivalry since 1979. We'll talk about his work, the Iranian Revolution, the influence of the Ayatollahs in everyday life of Iranians, the relationship between Iran and the United States, the morality police in Iran, the death of Mahsa Amini, the protests that have engulfed the country since, and what it might or might not mean. Chat soon, folks.